Good morning. This webinar offers closed captioning. To enable closed captioning, click on the live transcript button on the bottom of your screen and choose your preferred method. Welcome to the City of Chicago Department of Business Affairs and Consumer Protection webinar. Please note any website or email that I mention will be posted in the chat box. For those seeking business licensing assistance, you can visit the Small Business Center at City Hall on the 8th floor or call 312-74-GO-BIZ. Also, business licensing can be applied for or renewed online at chicago.gov/business licensing. The BACP Entrepreneur Certificate Program now has a new portal. If you are already part of the program, your account will automatically reflect the credit for joining this webinar within 24 hours. If you want to learn more about the program, please visit chicago.gov/BACP certificate. Also, this webinar is being recorded and will be available at youtube.com/ChicagoBACP. I will post the mentioned information in the chat box. We encourage attendees to ask questions. Please use the chat box to send your questions. There will be a Q&A session at the end of the presentation. Please note that the views, information, and opinions expressed during this webinar are solely those of the presenter and do not necessarily represent the official policy or position of the Department of Business Affairs and Consumer Protection or the City of Chicago. Today's webinar will be Recognizing and Protecting Your Company's Trademarks, Patents, Trade Secrets, and Copyrights, presented by Patrick J. Smith, partner and registered patent attorney at Greer, Burns & Crain. Patrick?
Thank you very much, Geraldine. Good morning, everyone. Thanks for joining me electronically. I hope eventually we move back to the in-person session. I like to stand up and walk around and move. I got to get my steps in. But this I think allows us to reach a wider audience. So welcome, everyone. Good morning. As Geraldine said, we'll do some questions and answers at the end. So if you along the way write a question in the chat, we'll get to those. I'll try and save 15 minutes or so to go through stuff. But really, what we're going to do here is kind of go over a high-level understanding of what intellectual property is, and where within your small business, whether you're starting or you've been going for a while, where you might encounter trademarks, patents, trade secrets, how you create them, and what kind of steps you want to take to protect them. So we'll go through these, and like I said, we'll ask questions. But I wouldn't be a lawyer if I didn't have to give a little disclaimer. So just be understood that I'm here just teaching a class, and I'm not trying to give anyone specific legal advice. And so my teaching does not create an attorney-client relationship. So all our questions are going to be hypothetical and discuss things hypothetically, not about any specific situations. Because in general, when you have an attorney, you don't want to disclose what you discuss with your attorney. So you want to keep that secret. So we're here to talk about intellectual property, and usually the first thing to think about is, well, what is intellectual property? And really, there are three types of property in the world. So there's real property, which is land, houses. Leases tend to deal with real property, so they're considered real property in some aspects. Then there's personal property, and that's all our stuff. So our cars, our watches, our phones, everything we have. And what I like about this is sometimes personal property becomes real property when it's attached to a house. So, in Illinois, sometimes a washer can become real property because it's part of the house that you sell. So it's kind of a little interesting, and sometimes the lines blur. But then we get to intellectual property. And so the question is, well, what is that? What are those? And these are rights for creative things, for things you come up with. But really, what's really important here is they're negative rights. They're the rights to stop people from doing something, right? The rights to stop people from copying something, or stop people from trying to trade off your name, or stop people from making something. So intellectual property is really a right to stop someone. So it's like I said, it's a negative right because it's a stop, not a go. So the core areas of IP, what we're going to kind of talk about today, there are 5, 2 of them overlap, but these are all things that you probably will encounter in your business at some point. And so you should be aware of what they are, what they protect, how they're protected, because there might be some overlap, but they are distinct. So the first thing we'll talk about is copyright. And everyone probably knows what copyrights are, but they're, to protect literary artistic works. They tend to last a very long time. It depends on who the author or owner is initially, but they can last to 95 years or 70 years after the death of an author. So they can last for a long time. You'll see this registration required. We'll talk about this. Aside from patents, none of these actually have to be registered, but there are benefits to doing so. Next, we'll talk about trademarks, which are names, symbols, other things that companies use to kind of distinguish themselves and their goods and services from those of others. If you register it, it's good for 10 years, and then you got to renew it. But as long as you're using that trademark, you can continue to have protection. Trade dress is pretty much the same thing, except it is what something looks like, the overall look and feel of a product or product packaging. So these two kind of go hand in hand, but they're similar but a little different. Next is trade secret. This is confidential information which you have obtained in your business, and as long as you keep it secret, you can claim and protect and make sure no one steals it. And finally, we'll talk about patents. These are for technological innovations. Two main types of patents are utility patents or design patents. So utility patents cover something, what it does or what it, how it is, like an actual physical thing. A design patent is like a trade dress. It's what it looks like. And the patents are the ones that registration is required. So you don't have any rights until the government has given you rights for a patent. The other ones, like I said, you don't have to do anything to register, but there are benefits to doing so. So with that kind of background, we're going to jump right in and start with copyrights, which maybe you've seen the circle C here. It's kind of the big thing for copyrights. So what's protected by copyright? Well, any original work of authorship fixed in a tangible medium. So I have 3 darkened words here because these are the words I want to stress. Original. So that means like you can't copy it from someone else, right? You have to come up with it on your own. So if I see a photograph on the internet, I don't get to take that photograph and then say, oh, it's mine. That's not original. A work of authorship. What's authorship? This bar is pretty low. And this is not to downplay poetry or anything like that, but some poems are very short. It doesn't take much to come up with a really nice poem. You don't have to do much, but you have to do something. And then fixed in a tangible medium. This is my favorite one to think about because if I go to the beach and I create a sandcastle, well, I've made a sculpture. Is that a tangible medium? Well, it's for a little bit until the tide comes in and washes it away. But really this means it can't just be in my head. I have to somehow get my original work of authorship from my head to something else. So if we've satisfied these 3 things, we probably have something that is protected by copyright. So what does it include? Well, the obvious things. So literary works. So within your business, maybe some books, author, or if you write product descriptions or advertisements. In Seinfeld, Elaine worked for a company and they had these very unique product descriptions in their catalogs. And so I always like those because I'm trying to sell something, but you're coming up with an original authorship to describe the thing you're selling. So that's kind of interesting. But musical works. So if you're a musician, a song that's recorded could have multiple copyrights. You could have the lyrics. You could just have the music. You could have a specific recording of that song. So musical works are pretty easy. Pictorial, graphical, sculptural works. So photos, pictures, movies, drawings, sometimes designs, sculptures, anything you're creating originally that's got some authorship to it could be protected. And so this can include displays, prototypes, technical drawings. But what we need to remember is copyright is going to protect expression, not the idea. So there's this kind of dichotomy to try and understand, well, all right, I have an idea for a book or a theme of my book of a boy meets a girl, boy falls in love with a girl doesn't like boy's sad, but wins the girl in the end, right? I don't have a copyright in that idea. But if I write my book and I tell the story and it's about a boy from the northwest side of the city and he falls in love with a girl from Rogers Park and all, life happens, that expression is protected. So that's what's protected by copyright is the expression. And this can play out a little more difficultly with things, right? With useful articles. So I have my lamp here, and you could see the lamp's got some nice sculptural aspects to it. And I'm going to try and use this pen because this is fun. But down here we have a little sculpture. So we definitely have some protection for this sculpture. The lampshade kind of has a pattern up here, right? So we probably have a copyright in the lampshade. But if someone just makes a lamp, well, that's what this does. It's not this lamp, what it looks like. So the copyright in this lamp would not allow you to stop someone from making a lamp. And just a quick note, the reason I use Mickey Mouse here is if you remember, copyrights have a very long duration with respect to copyrights owned by author, which we'll discuss in a second. They last for 70 years after the death of the author. And a big push and reason for that was this little guy right here and his author, which I believe we're starting to get 70 years from Walt Disney's death, because I think certain original works are starting to fall into the public domain now. But that's why Mickey Mouse is in this presentation. So where are you going to find these copyrightable materials in your business? Well, photos, drawings, music, songs, books. I mean, these are the easy ones. Things you're creating that are, have authorship, and you're fixing in a tangible medium, you're writing down. But logos, if you design a logo, or maybe someone designs it for you, we'll talk about that in a sec, and it's artistic in some manner, well, you might have a copyright in that. And we'll talk about how you might have a trademark as well. But these are different. If you remember, they last for a different amount of time, and there are differences between the two. So it's good to have overlap. You have a website for your business. There are all sorts of things that could be copyrighted on your website. You have the content, as I said, my description of my goods and services I'm selling. Behind the scenes, the source code. A while that was a big thing to copyright. Everyone was copyrighting all the source code for everything. If you take pictures and put images on your website, well, again, those are photographs. So those are probably copyrighted, but from where, right? Again, it's got to be original. So if I take a stock photo from the internet, first of all, I better make sure I have the right to do that. Just because it's out there doesn't mean I can. But if I take that doesn't give me the copyright then. So it's not original. And then the website itself, what it looks like. I have this kind of overall look on my slides. I might be able to say that that's somewhat copyrighted. I have this gray on the bottom, gray up here. I have this blue box over here, our green little logo. So you set this overall look on all my slides. Maybe I could say that's copyrighted. Advertisements, flyers, again, you're making things that have some sort of authorship, arranging things. There could be some level of copyrightability there. Employee manuals, materials, these again are written things. They're not as exciting as advertisements or websites, but you're taking time to create something, and you have a copyright and you can stop people from copying. So then I end anything written and typed. Well, maybe a contract, yes, there's some authorship when I write a contract, but it's kind of a legal document. A purchase order, again, maybe, but you're getting closer to some sort of functionality here with these types of documents. And as we talked about, as I mentioned earlier, copyrights don't protect a functional thing, right? They don't protect the idea, they protect the expression. So you've created your copyright. You've created something, and you have a copyright, I should say. So what do you do with it? Well, you stop someone from making or distributing copies, or from making derivative works without your okay. The making copies is pretty straightforward. It doesn't have to be an exact copy, right? It just has to be substantially similar. So you look and see, all right, how much did they borrow? Do they take 20%, 30%, 80%? To try and figure out if it's substantially similar, if they took enough. Again, it doesn't have to be exact. Or a derivative work. So the derivative work is where you borrow enough so that people think of the original work, but you change it up. So my wife's favorite book is Pride and Prejudice, which is, there's 95 different versions of the movie. However, my favorite version is the derivative work Pride and Prejudice and Zombies, where they take the basic underlying story and then they twist it a bit. They add more things, the story changes a lot, but they're enough that the characters are the same, that you think back to that original work. So that's what a derivative work is. So if a new work is substantially similar, or if it's derivative work, it might infringe. But you also have to show access, that someone had access to your work, because independent creation is not infringement. So if two people come up with the exact same story, independent of each other, no one had any idea about the other ones, they're not infringing each other's books, right? So it's not a copy if you come up with it on your own. So if I take a photograph of, right behind me is the Sears or Willis Tower, and someone else takes the exact same photograph, like we don't commit copyright infringement because we took the exact same photograph. That's because we independently created. But what happens if someone does? Well, there could be severe penalties. You can get an injunction, which means the court issues an order telling someone to stop doing something or ordering that they destroy certain things. You can get money, which could be actual damages, profits, statutory damages, which is a set amount of money damages, which is easier to prove in a lawsuit. And maybe you can get the other side to pay your attorney's fees. So, these attorney's fees, they tend to be high, and any time you can get those from someone else, I would say that's a severe penalty. One thing to consider, and I mentioned this as we started, is who owns work. And it's owned by the author, but sometimes it's kind of tricky to figure out who that is. And actually, who that is then dictates how long it lasts. So if the author is a natural person, me, I write a book, then the copyright is owned by me, and it's going to last for 70 years after my death. If I'm hired to write a book, so this work for hire, let's say my company hires me to write a book, or I sign a contract with a publisher to write a book. Well, the book may show me as the author, but the company would be the author for purposes of the copyright itself. And in those instances, when you have an employee creating work or commission work, those copyrights last for 90 or 95 years from publication. So because those are not tied to a natural person necessarily, they can't be tied to the death, because a corporation may never die. So who is the author for copyright purposes is important to figure out how long the copyright will last. And there's a lesson here, and we'll talk about a couple lessons along the way. And this is kind of a theme to all the lessons, is we got to get stuff in writing and get it done in advance instead of after the fact. So if you're hiring someone to create some stuff for you, make sure you get this stuff, iron this out in advance in writing. So if you're hiring someone to make a web page, make sure it says you own the copyrights. If you're hiring someone to design a logo, make sure it says you own the copyrights. That's what we want to do is, while maybe we could prove it later, we don't want to do that. If we can avoid proving things by having a written agreement done first, let's do that. So a lot of these lessons along the way are going to be figure it out beforehand and have something in writing. So as I mentioned, copyright registration is not required. So it's considered like a natural thing that when you create something that's copyrightable, you've automatically created the copyright with it. So when I write my book, magically behind the scenes, some clouds and fancy music, and there's a copyright with it. I don't have to do any registration to create the copyright, but if I do want to sue someone to stop for infringement, I do have to file a registration to do that. And so, but it's not required, but if I'm going to sue someone, then it is required. Additionally, if you do it early, I think it's within 3 months of publication, there are these benefits of statutory damages and attorney's fees. If you wait, if 20 years go by and then you register it, you're not entitled to get these types of damages. You can still get other damages, but these damages, which are the severe damages and the easy ones to prove. So, a lot of times people might say, well, I take, 1,000 photographs, what do I do? And I say, well, you can register them in a group or pick ones that you think are really good and register just some of those. Because if you do thousands of photographs, it can be kind of expensive. But one thing you probably want to do is do copyright notice. You use your little circle C, you do the year of publication, the first year, and you can put the owner's name. It's not required, but it does show that you claim a copyright or someone claims a copyright. And the inverse isn't true. So just because the C isn't there doesn't mean you can just copy the work. The internet is the Wild West of copying stuff. And so a lot of times there aren't C's, but that doesn't mean you can just use that photo. So just because it's not there doesn't mean you can grab it. So how do you register? Well, registration is done by the Library of Congress, and specifically the United States Copyright Office. This is their website. You can either do online registration or a mail-in form. It is pretty straightforward. I think it's a page and a half of information, and mostly it's who you are, what's the good, what are goods, the work you're registering, and some basic information. The fees I just looked, and I think these are still accurate. $45 to $125. It depends on how you do it, online versus mail. And it also depends on what you're registering. If you're taking your 1,000 photographs and registering a compilation, they may charge you a little more. How long does it take? So relatively fast, which could be 8 to 14 months. We're dealing with a federal government branch here, so things take time. But I did have one, register in 2 months. So just because 8 to 14 months is what they say is the average, that doesn't mean that's how long it's going to take. But all you do is you fill the form out, mail it in, or submit it, and then most of the time they write back and say, "Here's congratulations, you're registered." Sometimes they raise issues, but usually that's not the case. So we're going to move from copyrights now to trademarks. And so the copyright was a circle C. Here are 3 symbols that you probably have seen, that companies use with respect to trademarks. Again, you don't have to use them, but they are helpful. The circle R is registered trademarks. So you're only supposed to use this one if you've got the registered trademark from the U.S. Patent Office. People use this TM here. If they're using a mark, they haven't filed for registered trademark, or maybe they have and they can't get it, but they still think they're entitled to it. And SM is just like a TM. T stands for trade, S stands for service, so service mark, but the same thing. Typically it's unregistered, and then you use it to kind of indicate you think this is a trademark. So what are trademarks? Well, trademarks are words, symbols, logos, lots of things. We'll talk about what those things could be, used by a business to identify its goods and distinguish its goods from the goods of others. Service marks, pretty much the same thing, except it's the source of service. Marks must be distinctive. There's my typo. So what this means is the mark must be able to operate as a trademark. It must be distinctive. The whole idea of the trademark is is that I'm using something that creates this connection in the minds of consumers between that mark and some level of goods or services. So I see a little swoosh on a shoe. I may not know the company that makes those shoes, but I know those are good shoes. I see a mermaid with hair coming down on a coffee cup. I may not know who makes that coffee, but I know the quality of that coffee. And so if I see that mark, I'm going to think of that company's goodwill. And so that's what trademarks, service markers do. And that's why they have to be distinctive. And so there are lots of different types of trademarks out there. Words, symbols, logos. So we're going to start with words because those are the easiest. And there's kind of this level of whether or not it could be protected, whether it could be a trademark, whether it gets to distinctiveness. So we'll start at the bottom here and use a generic term. So if I want to make a shoe and I want to call my shoe, that's considered generic, right? It's literally what it is. That will never operate distinctively, and the trademark office and courts will never say that that's able to be distinctive, because that's what it is. That's what everybody calls it. And so if I use a generic term and try and say it's a trademark, well, that's probably not going to work, and it won't work. So then we kind of move up our ladder here to the next level, which is descriptiveness. Now, everyone always likes descriptiveness because they say, well, I'm just describing something about my goods, which is good and helpful, but it's really hard to show distinctiveness for something that's descriptive. So if I have a store for selling shoes and I call it Shoe Land, well, I mean, kind of describing, I'm not selling a land of shoes, so it's not generic, but I'm just kind of, it's an area where I'm selling shoes. It's describing what it is. Courts and the trademark office, they're really hesitant to give protection for descriptive marks because they kind of describe what you're doing. It may not be generic, but it's descriptive. So if you have a descriptive mark, they're going to require you to show the secondary meaning. They're going to require you to show that you've acquired distinctiveness, you've created that connection between in the consumer's mind, between that mark and this source, that source. And that can be difficult. We'll talk about a couple cases where that happened in a sec. But one thing to note here is words that are primarily a surname, so like Smith, they're kind of treated on the same level, that either they're generic, descriptive, you have to show secondary meaning if your mark includes something that's primarily a surname. So what I like to tell people is, I got it up here, is do one of these three for your marks, right? At a minimum, we want to be suggestive, right? Consumers are smart. We don't want to have to give them all the information. Maybe we want to let them make a little connection in their head. So if I have a shoe store and I want to call it Laces Up, well, all right, I'm connecting in the mind, all right, laces, well, shoes, okay, I'm making them think about that. So it kind of suggests, hey, laces, those are shoes, maybe they're selling shoes there. They're suggesting that connection. I'm not describing the connection, I'm suggesting it. So once I have a suggestive mark, I don't have to show secondary meaning. It's suggestive. It's able to be distinctive on its own. So that's okay. I can move up a little higher and come up with an arbitrary mark. So now I have a word that has nothing to do with what I'm doing, right? So pickles for shoe stores, or I don't know, Apple for computers. These things have nothing to do with, I should say, when they started, they had nothing to do with what the goods are. So it's just this arbitrary term. So again, that's fine. There's distinctiveness there because there's no connection. And then finally, fanciful. I made up a word. Well, okay, if you're making up a word, that's pretty good indication that it's distinctive because you made it up. So if I use Jub, which someone else made up, but I borrow it, for a shoe store, it's a made up term. That's the highest level we can get, because it acquired distinctiveness because no one had that word before. So the word marks, you could claim it as plain, so plain old regular text, or I should say, stylized. So you could have two trademarks, one in the plain version and one in the stylized version. You may want to do that. You may not. It just depends. You can include a color claim, no color claim, lots of different ways you could tweak the word to protect your word mark. So I'll show you an example here of a stylized word mark. So this is Wilson, which I picked because they're from Chicago and I like Bryn Mawr Avenue. So, and I grew up with this on my baseball glove. But this is a stylized mark, so it's a specific font. And you'll see down here, it says the section 2F. Hopefully you can see that. What this means is they had to prove secondary meaning. And I didn't look this case up, but my thought is maybe they said this is merely a surname. And so they wanted them to show that they've been using this for a long time. People think of Wilson in the sporting goods industry and think of their company. But this is what a trademark registration looks like for a stylized word mark. But again, you get a plain word mark. This is another good one. So this is McDonald's, and they have a registration for 2 all beef patty, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. Yes, I always hope I can get through that. So that's their word mark. It doesn't matter what it looks like. Again, something to note here, section 2F. I'm guessing they said this is descriptive of what you're selling. So they had to come in and say, no, this phrase that people think Big Mac. So that's protected, or at least it was protected back in 1983. I haven't looked to see if they still have protection. But beyond word marks, there are other types of marks, as I mentioned before. So sometimes symbols can be trademarks, right? So here we have this radar symbol, which is kind of common. It's out there. But Apple's claimed obtained a registration for computer software. And what's interesting here is that it's the color is important here. The colors white, light blue are claimed features of the mark. So it has to be this mark with these colors in this manner. So my guess is that helped them because it made it more specific than the kind of generic radar looking symbol. A logo. I think we all know this logo. And so this, is a logo that someone created. And actually, I picked this one because the IP dispute behind this, and there's a photograph that the logo is based on. So does the logo infringe the copyright of the photograph? And all this stuff is kind of an interesting story. And goes to show how IP is in all facets of our life. We may not notice it's on our shoes, but anyways, so this logo right here, this is a trademark. There's no words involved. It's just a little image of something. Now, if someone created this on their own, this could also be a copyright. And so you'd have dueling protections. But logos, symbols, when you start to get to that, you may have multiple protections. We also have some non-traditional trademarks. So sound can be a trademark. I have the NBC chimes, but if you have kids that have seen movies in the last 10 years, the little minions, they do their little sound. That's a trademark. The Universal Pictures at the beginning, that music played at the beginning of movies. Color can be a trademark. The blue for Tiffany packaging, that people see that color, jewelry box size thing, and they think of one place. Fragrance, so there are dolls that have a smell. Product or product packaging. This is trade dress, but the old glass Coke bottles, or the design of a business establishment. A lot of fast food restaurants have a theme, and whether I go in a restaurant here or in Ohio or in Wisconsin, they all look the same. That theme could be a trademark or trade dress. Fabric designs and patterns. So Burberry has a lot of trademarks in their patterns. And like copyrights, trademarks aren't going to protect anything that's functional. So it has to be distinctive. I put green color here because, and I don't know where the cases are because they keep going back and forth, but there's a company that makes tractors that wants them to be green, but there are some judges that have said, well, there's a functionality to having that green color for the tractor, so it can't be a trademark because it's functional. So if you're into colors or some non-traditional trademark, just make sure it's not doing anything functional, and you'll be fine. It has to be distinctive, and can't be functional. So what are your potential sources of trademarks you'll have in your businesses? Well, your company name, as long as you're using it with goods and services. If I just say Smith Enterprises and I don't put that anywhere, that's not good enough. In addition to the fact that it's Smith Enterprises, but you have to use it with the goods and services. So if I have a product, then name or lines, it's on the goods and services on that's great. That's protectable. Service levels, I have a gold level, silver level. Maybe that's not enough, but I come up with names for different service levels. That's probably going to be a trademark. Logos, again. So if I create a logo, that's great. But remember, if I'm creating it, maybe I've created copyrights as well. So these are kind of the major sources where you find your trademarks. And who's going to own that trademark? Well, in the US, it's the first to use / register. And you can't register it until you use it, but you don't have to use it to file. So there's a little kind of play back and forth here. So in the US, rights are required to maintain through use. So as long as I'm using the mark, or maybe I've stopped for a little bit, but there's an excuse for that, and I'm not intending to give it up, then I keep those rights. I'm not required to register, but it is helpful, especially if I haven't started using it yet. And we'll talk about that in a sec, which is this intent to use registration. If you're using it, maybe like we talked about before, you haven't got a trademark, but maybe you throw a little TM after your name, Jub TM or whatever. If I get it registered, then I'm going to use that circle R. I should say this, in most US states, I don't know if it's all, but most US states have a state registration system for trademarks. It's a little different. Honestly, I don't use that very much for my clients. There are instances where maybe you would do it, but usually you want to use a federal registration. Just a quick note, outside the US, most countries, including most of Europe, are first to file. So it's not necessarily they used it first, they filed first. So that's kind of a little opposite ours, because unless you have an intent to use, you can't file for a trademark unless you used it. So just be aware of that outside the US. So one thing to know about trademarks is you have to police and enforce them, right? This is an affirmative duty. If I own a trademark, if I claim trademarks, I've got to take steps to stop people from using. If I don't do anything, and I see someone else using my mark and I let it go for a long time, well, there's a good chance I won't be able to enforce it, and there's an even greater chance that I could lose protection entirely. So if you don't police it, marks can become generic, and that means you have no protection. Again, we want to prevent the consumers from being confused. If two people are using the same mark, they can't figure out whose goods they are. And it's not on any goods, right? It has to be similar goods. So if I'm using one mark for shoes and someone's using the same mark for computer services, that's not confusing and similar. No one's going to think those are two of the same companies. But if I'm using shoes and someone's using laces, well, then we have a problem. But if I don't police my mark, it could become generic. So I got a couple here. Escalator used to be a trademark. It's not, right? It's generic for what it is now. trampoline, that used to be someone's trademark. Now that's what it is. Aspirin in the US is generic. Outside the US, it's still someone's trademark. So know when you're traveling, aspirin is a branded thing outside the US, but not here. So how do you police it? Well, you can just do simple internet searches for your mark and see if anybody's using it. You can subscribe to a watch service who will do searches like that. They'll watch the trademark office to see if anybody's filing anything that's similar, let you know. And if you do find someone, you got to write them a letter. You got to ask them to stop. You got to do something, because if you let them do it, eventually you're going to erode your own rights and you're not going to have any protection. Proper trademark use. So how do we make sure we're using our trademark properly? Well, we try and distinguish the mark from surrounding text, right? So you see in my next sentence, I have UGG capitalized or Kleenex capital. Like, you know, when I write letters and when we talk about marks, the marks are always capitalized to set them off from the surrounding text. Maybe I bold them, maybe I stylize them in some places, maybe they're bigger colors, but you just set it off. If it's in a body of text, make it pop. And that helps create that secondary meaning, right? That you look at a bunch of text. Well, I'm going to see that big bold word that's in capitals and, you know, sparkling and has all these fancy lights flashing around it. That's where I'm going to look. And always use the mark followed by noun. So if I'm talking about boots that were made by Deckers, and they're called UGG brand boots, I talk about UGG boots. I don't say, look at those Uggs. I'd say UGG boots. Same thing, you know, I don't want a Kleenex. I want a Kleenex brand tissue. So especially for your own marks, you should use it like that. Don't pluralize it. So don't, again, this is kind of this, use it with a noun. Don't say Uggs, Kleenexes, you know, it's a UGG boots. Don't use your mark as a verb. Don't tell people to Xerox the document. They copy the document on a Xerox copier. Google, I mean, we all do this. I do this all the time, right? Go Google something. Well, no, that means go search the internet for something, right? Google is a specific search engine. So I think Google's probably famous mark, so I don't think they have much to worry about. But the idea that Google is a verb for searching the internet is potentially harmful to Google's rights in that mark. You have to use the mark in commerce. And so that means honor and association with goods or services. The US is a little weird here, but for goods, advertisement doesn't count. Just because I'm advertising my goods with my mark, that's not enough. I have to have the mark on the goods as they're being sold or in packaging or with them. So, you know, and there are exceptions. Outside the US, you know, companies love that, or countries love to look at advertising, which I think makes sense to me. But you have to be aware that, you know, advertising may not be enough. You have to, you know, slap it on the goods. And it doesn't actually have to be you doing it. So if you have a relationship with a company, their use could be for your benefit. So if I make shoes, but somebody else, Foot Locker, sells them, that's fine. You know, their use and selling my goods is good enough. Even if they have someone make them for me, as long as I maintain a little quality control, I can go and inspect and say those don't live up to my high standards. That's fine that someone else is using your mark with your permission. So I've talked about this common law, federal registration, why you don't have to register, but maybe you should. If I'm just using a mark without any registration, I'm typically going to be bounded by my geographical area of use. So if I only use it in Chicago, maybe I get Chicago and a little bit Indiana, maybe some Wisconsin, but not much, right? Product or service has to be on the market. I have to be selling something. I have to be doing something. And if I am doing all this work, you know, there's a coffee shop that's opening up by my house. And I think I saw it's an opening in 2024. And they have, you know, some name. Well, if someone opens a coffee shop next to them and starts selling before they do, they might not have trademark rights in that name, right? Because they're not actually doing commercial sales. They're not doing anything. They're taking steps to start to do stuff, but they're not doing stuff yet. So, you know, they have to be a little careful. On the flip side, the federal registration, if I get it, I'm still using it just in Chicago, but I have a federal registration. Well, then now everyone in the whole country is on notice that I have this right. And I don't have to actually be using the mark yet. I just have to have a bona fide good faith intent to use the mark. So I could file my registration and say, I haven't used it yet, but I'm going to use this mark. I really think I'm going to use this mark. So they'll examine your application. They'll say, okay, we're ready to go, Pat. You have 6 months to show us use. Now I can extend that for some time, but they're not going to give me a registration until I use it, but I'm able to file my application early. And this allows us to kind of expand. I get my date in. So if someone starts after that date, well, I can always go back to that earlier date. Even if I haven't used it yet, I filed earlier. So it allows you to expand at your own pace. It allows you to have that priority date, even though you haven't used it. Another thing it lets you do is you can record the registration with the Customs and Border Patrol and get them to seize goods that are coming into the country legally. If you're concerned about doing that, we can talk more specifically about that. But that this is one benefit that is afforded to federal registrations. So how do you get a federal registration? If you're curious, well, the U.S. Patent and Trademark Office. So there's 2 departments here in the same office. They're all part of the Department of Commerce, the federal government. So here's the general PTO website, and then the specific trademark one. You file an application online or in paper. Fees are actually not that high. You can do the application yourself. It's pretty straightforward. It's just you have to be sure the ownership and to the correct information is right, because it can be kind of tricky to fix it if something's wrong. Again, fees are pretty low, and you can if you e-file it, it's cheaper. And the more classes or goods you have, the higher the fees go. Registration again is relatively fast. The first decision is in about 6 months, and let's say about half the time they come back and say, no, you don't get a trademark, you have these issues, or there's somebody else out there, why are you different? So you might have to argue back and forth with them a little bit. If you want to use a mark, you don't have to do a search, but it may be helpful to see if someone else is using it. You can search the trademark database at the PTO. Here's a website that you can do that. There are other companies you could hire that will do a full-on search. They'll search the patent office records. They'll search the common law. They'll search the internet. They'll search state records. So you can do that if you want to get a little insurance before you start spending money and developing a mark. And we'll briefly get a touch here on trade dress because that's very similar to trademark. Instead of a logo or symbol or something like that, really, it's kind of the overall impression by a design, configuration, packaging. Again, it's got to be distinctive. So that's kind of, we fall back to this, something distinct about it. And it's really a type of mark. So the overall look of a store, how a product packaging, the Coke bottle, the look of a product. And the easiest way to understand this is probably a couple examples. So the first example here is this vitamin water and the Santi case. So I think this was the trade dress, one over here. And they listed all these, the factors, right? Bell-shaped plastic bottle, vertical presentation of words, two-tone, white, matching color of the water, clear cap, clinical look, whatever that means, and sub-brand names. So that's kind of the, I don't know if they found this to be confusingly similar or not, but that I know there was a dispute about this. So this product packaging trade dress. Here's another one, is a registration. And it describes that the mark is a three-dimensional configuration of an oval-shaped depression in a navel on a bottle. So essentially this right there. Doesn't matter what this dotted line means it doesn't matter what the bottle shape looks like. It's a bottle that has that there. So that's someone is claiming that that little thing is distinctive to them. Here's another one. I don't know that you've maybe seen this one. I think I actually have this iPhone in a drawer on my desk, but the mark is a rectangular handheld device, silver edges, black face, 16 squares with rounded edges, top, right? This is the first iPhone. So they registered this to show that how this looks, not what it does, not that it's a phone, or so you could make a candy one that doesn't function as a phone, but it's identical to this. Well, they could say that's Apple could say, well, you're infringing our trade dress. You're creating something that's confusingly similar. So it's not what it does, it's what it looks like. Registration, again, that's going to be similar to trademarks, right? There's no functional aspects being protected. So again, go back to my iPhone. It's not that it's a phone. So if it's a candy dispenser, but it looks the same, well, that could be problematic. It's got to be distinctive, either inherently. So if we're doing those word marks, it's suggestive, arbitrary, or fanciful, or you have secondary meaning. Secondary meaning is typically hard to prove. You have to come in with a lot of evidence showing you've been using it for a long time, that you spend all this money on your marketing, and then people spend all this money, they wait in line to buy the newest phone that looks like this. So it requires a lot of evidence. But if you have a product, it may be worthwhile to protect it. And the protection is similar to trademarks. So you have to kind of police it yourself, write to people and get them to stop if you see something that's similar to what you're doing. So we're going to stay with the trades and go from trademarks to trade secrets. And if you recall, these aren't registered, right? So there's no place where you send in your secrets to register them, which is probably a good thing. But what are trade secrets? Well, trade secrets are formulas, patterns, devices, methods, process, compilations of information used by a business which provides an opportunity to obtain an advantage over competitors who don't know it. Okay, what does that mean? It means I have something in my company's possession that gives me a competitive advantage, right? And competitors may not know this information. Maybe they can figure it out, but they don't know it. So there are lots of different things that may fall into this category. It has to be confidential, and you have to take some steps to maintain the confidentiality of the trade secret. And what happens in all these cases is somebody takes something that's a trade secret, and then they fight about it and determine whether or not it was a trade secret. So this section is more about some pointers to think about, steps to do beforehand, because when this becomes an issue is usually after it's been taken. So again, there's no system or process for registration. It's proven in a lawsuit, and you lose protection once it's no longer a secret. So if somebody takes your secrets and publishes them for the world, that's not good for you, because the bell can't be unrung, as they say. So what are some potential trade secrets you might have? Well, marketing plans, strategies, customer lists, supplier lists, business plans, employee compensation. I like this one because if you're paying your employees a little higher than everybody else, or giving them some sort of something that makes them want to work for you as opposed to next door, well, maybe that's a trade secret. Maybe no one knows that's why the employees are coming to you and giving you an advantage. You're never searching for help. People are always wanting to work for you. Non-public recipes, designs, formulas that can't be reverse engineered. We'll talk about this in a sec. I just want to talk about processes for making foods or products. So if I have my wife makes salsa all the time. If she has some little tweaks in her process she uses that makes her salsa the best, and it is the best, I hope she keeps that secret from everyone, including me. I'm happy to remain a taste tester for the rest of my life. But one trick is it cannot be reverse engineered. So if I have a device that I say is a trade secret, but I'm selling that device, someone can open that up and reverse engineer my device. trade secrets aren't going to protect me. So if I have a recipe and there's a secret ingredient and someone can look at it and figure that out, that's not going to help. So the greatest example is Coke. The Coca-Cola formula is a secret recipe, right? Nobody's been able to reverse engineer it. Everybody's trying to copy that formula. And if they can, without stealing that formula, they can't, Coke can't do anything to stop them, right? But no one's been able to figure that out yet. So if you put something out there and someone can reverse engineer it or figure out, or any of these, someone can figure out your customers because you put them on your website, well, that is not really a secret. So anything can be figured out or reverse engineered is probably going to lose trade secret status. So that's why we want to protect our trade secrets. So how do we keep those secrets secret? Well, I mean, you got to do something. Maybe you just mark it confidential. You got one of those big stamps and you just stamp everything that you think is confidential, or you click the button on Adobe. You keep access limited to employees or contractors who need to know. Not everyone can access all the databases in your server, something like that. Agreements to maintaining confidence. So if you hire an employee, give them information that you don't want out there, make sure that agreement, make sure one, we're getting an agreement beforehand, and two, we're including there a agreement to keep it in confidence. Basic things, again, password protection. Documents are password protected, or computers are password protected. Access login information is password protected. Lock your doors. Keep the server room locked or something like that. These are, and I give these examples because these are things that companies didn't do and claim that they were taking steps to keep secret. So this means that someone didn't lock their doors. Limit control copies. I think, usually nowadays you can kind of password protect things where you can send it, but can't copy it or send functionality. And again, going back to this employee agreements, have a policy on USB drives and copying. And maybe now you need to have it with AirDrop or whatever, but just policies about company or employees, putting something in their computer, a couple clicks and drags, and then they've copied everything onto USB. Because a lot of times that's how things get copied, and it's pretty quick. But again, what happens is these secrets get taken, and then that's when the dispute really starts. So what we want to do is, if you think you have stuff, just take a few steps to keep it protected. Limit it from being disclosed, because once it gets disclosed or figured out, that's where the problem is, and so we want to protect that and avoid that from happening. So I have about half an hour left, and we're just about to get into patents. So this should take a few minutes, and then we'll start getting in some discussions. I see I don't know if I could see 8. I'm not going to click on it to see if there are, but you can put your questions in the Q&A or the chat, and we'll try and get through those by 11. So patents. We'll talk about this last group of this last area of IP patents. If you may recall, this is the only area that requires registration. You have no patent rights until the federal government has said, Pat, you have patent rights. So you must register, you must get a patent to have patent rights. So patents, again, it's the grant of the right to stop others from making, using, selling, offering for sale, or importing the invention. And what could be patented? What's the invention? The invention has to be useful, novel, and non-obvious. These are kind of the three big standards, the three things that the patent office goes through to examine your patent on. Useful use. Previously, no one thought about this, but now there's some issues, especially when it comes to computer software and biological inventions, about the usefulness / novelness, whether you can get a patent on that type of stuff. But novel typically means new, right? Someone can have done it before, and usually you can come up with a way to describe your invention where no one's done it before. The next one, non-obvious, this is kind of where I spend a lot of my time arguing about this. This is where there is a difference, but the patent office thinks it's not an important difference. It's an obvious difference. Like, well, you had 3 doors on the car and you added a 4th. Like that, everyone would think to do that. And I say, no, the 4th door is in the bottom, and it's to when you're driving over something that you can drop out the bottom. Something like that. I don't know. So we that's where a majority of my arguing comes into place. Do you have to conduct a patentability search? You can. You don't have to, but it's kind of like insurance, because you'll see filing a patent can be expensive, and so figuring out what's out there, what's been done, because just because you don't see anybody selling something like that doesn't mean someone didn't try and patent it before. Do you have to conduct a non-infringement search? I'm going to sell this product. Do I have to make sure no one patented it? No, you don't have to do a search, but patent infringement doesn't require knowledge. So I don't have to know something that there's a patent. So a lot of times companies, before they introduce a new product, will do a search to see if there's going to be any infringement issues or not. But if you're thinking about filing a patent, timing is important, because you have to file within a year of your first public disclosure for U.S. protection. And the sooner the better. The U.S. changed laws. It used to be recently, but I've been talking about this for a while now. But the U.S. changed laws where your first public disclosure is, you still have a year, but sooner the better, because someone could come in between you, and that could hurt you. And you could lose the right for protection. So if you're coming up with an idea, usually the best advice is to file for a patent before you disclose it publicly. And that's because outside the U.S., you have to have done that. If you have to go to a trade show and show something and then file for a patent application, a lot of countries outside the U.S. will say, nope, sorry, it's not new. You just showed it, right? Someone's seen it before. The U.S., they give you a little grace period, because we traditionally like to think of the inventors as somebody in their garage at home coming up with stuff at night. So there's this desire to protect inventors like that compared to giant companies that invent millions of things a year. So that's why the U.S. is a little different. One of the things you can do is you file what's known as a provisional patent application, which is a placeholder. So I prepare an application, I file it today, which means that I have a filing date today. Then I have a year to show it, talk to people, finish my patent application, and file a regular utility or non-provisional application. So a lot of companies like to proceed this way with a new product or new patent to figure out if it's a product they're going to sell or do anything with. But that's something to consider. There are 2 main types of patents, utility and design. There actually are 2 types of flower patents as well, or plant patents, I should say, not necessarily flower. I won't talk about those. And if you are a botanist that is breeding plants, that's a pretty cool job. And the patents are the prettiest patents in the world that they get. So I wish you well. But utility patents, what are those? Well, those are for useful inventions, the functional features of a process, machine, manufactured. So my iPhone, I don't care what it looks like. It's a phone with some sort of features that's new. Design patents, this is the opposite. It's what it looks like. So I don't care how it acts. It's the overall shape of the article. It's not its functionality. So it's just like that trade dress, the iPhone trade dress. Well, if they have a design patent on that, again, it doesn't matter whether it's a phone or a candy container or a makeup container. If it looks like what it looks like, then that's a violation of the design patent. So I have an example utility patent here. Maybe you've seen them. Utility patents have a cover page with some basic information about filing date, issue date, who's the inventor, applicant. This may change, so this is just when it's granted. So sometimes companies buy and sell patents, so just because it's on the front page doesn't mean that's who currently owns it. This one is a fun one. We'll talk about So then it has a figure, and I kind of truncated these pages, but there's this first page has a figure down here, and then a couple other pages of figures. And then there's pages of these columns of text, two column texts, and it ends with claims at the end here, which are these numbered paragraphs written in a very confusing and awkward manner. This patent is entitled Method of Swinging on a Swing. So someone who was a patent attorney, and he wanted to show how sometimes things get through the patent office, let's say. And so he filed a patent on how you swing on a swing. And he got it. And then he kind of talked about it. And then the patent office, there are procedures for this. The patent office actually revoked this patent. So everyone is free to swing on swings. You will not infringe his patent. And I do think actually he got in a little trouble for doing that. But maybe he didn't. But in any event, this is what a utility patent looks like. So it's this cover page, figures if needed. Some don't have figures, but most do. And then columns of text. The design patent, it's a little similar, but there's not as much text. So you'll see again the cover page, all this information up here. And then it's all images. Again, because what a design patent covers is what something looks like. So everyone's decided, all right, well then just show us what it looks like. So this is a grill that's a pig. And you're happy to know this is expired. So without infringing the design patent, you can make the grill. However, assuming they came up with this design on their own, they could have a copyright in this. So their copyright might outlast, will outlast their design patent. So we might not infringe the design patent. We could infringe the copyright by making this design patent. Here's another one. So again, this design, which aligns with the trade dress we saw earlier, is going to protect what this looks like, not what it does, but what it looks like. So if someone else makes a product that's completely different in function, but looks like this, well, then the design patent will allow you to stop them. And so what can be patented? Well, in theory, anything man-made under the sun that meets the statutory requirements, right? So it's useful, not obvious, and novel, new. So products, items, devices, things, processes. So a new way of making something is patentable. That's one way that many companies file patents. There used to be a lot of companies found business method patents. They were called like a method of doing business. That was very popular for a while, and then this law changed, and actually those specific type of patents were attacked pretty heavily. And so now really that's not a viable option. Computer software is, I'd say it's swinging back to, it's getting easier. But for a while, the US especially, it was a very difficult place to get any patents for computer software for many different reasons that would take longer than the time we have to discuss. But if you're coming up with computer software, can you get a patent on it? Maybe. You have to do something new, and so it's a little more challenging, but it is possible. So patent inventions designs are usually marked with patent number or patent pending. If you're making something that's patented, actually you have to do this and you want to collect damages, right? So if you have a patent and it's for your your mug, on the bottom you better put patent pending or patent number or patent pending, so that when it comes time to enforce that, you can rely on that. If you don't do that, you may not get as much damages as you want, and that's
usually what you're getting at when you want to stop someone is damages. Infringement is when you make, use, sell, offer, or import the invention without permission. Again, I don't have to know about it. I don't know that mug is patented. I make the mug. I had no idea. Unfortunately, that is not a defense. It might lessen the damages, but there's still potential infringement. Again, we get back to the serious remedies, right? You can get attorney's fees if you win, and that's when somebody knew about a patent and they said, forget it. I'm going to move forward anyways because I don't like them. I don't think it's worth it. So that and tripling damages, again, these serious remedies. If you know of a patent and you go full speed ahead anyways without talking to an attorney or figuring this out, that's the serious remedies. So that's something you want to avoid. And then you can get an injunction, which is again the court order stopping, telling people to stop, destroy things, can't do stuff in the future. So there are some serious remedies available out there. One thing to think about is who owns a patent. And I got to give you my favorite lawyer answer was, it depends. Typically they're owned by the inventor. Well, that's my invention, but they can also be owned by an employer. So if my job is to invent things, that's my job is to invent things in this field. Well, then my employer is going to get all the inventions, right? I'm the inventor, but they're owned by the employer. If I hire someone to invent something specifically for me, I have this problem, I need you to solve it. Again, it's probably going to be owned by the employer, the company that hires them. But we're getting back to this, just get it in writing, right? Just have an agreement with the people that says, hey, employee, you're going to do this. You're going to create all these things. I'm going to own them. Because figuring this out after the fact is expensive and time consuming, and it would save a lot of time if we just did everything up front. We explained everything up front and said, hey, this is who's going to own. Why does it depend? Well, it can depend on state laws. There are 50 states and a bunch of territories and other areas in this country that have laws, and they all have employment laws that are somewhat different. So they all might have little tweaks here. So I have this caveat down here, the Illinois Employee Inventions Act. And from what I recall, what this act says is if I have this kind of agreement with my employer to invent stuff, but then I invent something on my own, well, that employer doesn't own it. If I go home in my garage again and I come up with a new shoe when I've been hired to create cars, well, okay, the employer doesn't own that, even though there's a writing that says anything I create is owned by you. So here's my lesson. Agreement is important. So just put clauses in contracts. In general, anytime money's changing hands, you're paying somebody for something, a writing is good. Doesn't have to be a lawyer writing, doesn't have to be 20 pages long. Just, hey, I'm giving you this is what's going to happen. How do you get a patent? Registration again is required. And, there's no easy way to say it. It's costly and it takes time. I'll give you some numbers in a sec, but once you get that patent, then you have to pay maintenance fees. In the US, it's essentially 3 times you'll do it. But you have to keep paying to say, hey, I want to enforce this. Otherwise, becomes, it goes to the public domain and people can then take from the patent. If you remember, these are all intellectual property rights are rights to stop someone. So it's not necessarily a right to use. So if I come up with a new drug and I get a patent, that doesn't mean I can make the drug. Somebody else is going to tell me whether or not I can do that, but I can stop other people from making the drug. Again, I don't have to wait till I have something ready to market or a product ready to go to file a patent. I can file at any time. And the protection is defined by the claims. And like I kind of mentioned, there's these paragraphs at the end of a patent that describe what the invention is. They're called the claims. They're written in very interesting manner. And so it can be kind of confusing, but that's where you can figure out what the patent actually covers. The process, again, this is the Department of Commerce, the USPTO. There's a website. This is the patent side of it. Again, you can file online or in paper. I think the way it works now, if you file in paper, you have to pay a bunch of extra money, surcharges. But For a small entity, the cost to file a utility application is now $728, which is actually lower. They kind of reduced how they figure that out. Patent attorney's fees, so what someone like myself might charge for preparing an application, can range between $5,000 and $10,000. Again, you don't have to do a search before you file a patent, but again, when you start to look at some of these numbers, sometimes you want to figure out what's been done before. And as I note, use this if you're going to search for patents. I highly suggest patents.google.com, the Google Patents search. It's pretty straightforward and really easy to use. So you file your patent application. What happens? Nothing. Hopefully within a 1.5 to 2 years you get something, but maybe not. It takes a while, and this most of the time involves 1 or 2 goes back. So it can take. The goal of the USPTO is to have the patent decided, either granted or abandoned within 3 years from filing. So it's a long process, and you have to pay the various stages of the prosecution. But if you come up with something new and you have the time and the money to invest, it is a way to protect that from being copied. Provisional application that I talked about before, the fees are a lot smaller. It's $120. That's because nothing happens. Just you pay to have it sit there, and then in a year you file something new. A design patent application, again, for a small entity, which is a company that has fewer than 500 employees. It's $417, and you have to pay an attorney to prepare the application, but it's usually much less than the $5,000 to $10,000 for a design patent, because it's mostly drawings. But at the end, you filed, wait your turn, and eventually, hopefully, you get a patent, and then you can consider writing letters to companies and people telling them to stop selling infringements. And so with that, I've reached the slide that says questions. And I'm looking at my clock, it's 10:50. So I will endeavor to get through all these questions, and can stick around until the BACP kicks me off. Or till like 11, a little after 11, I do have to get to something else. But I will take a look at any of these questions. So in the web chat, let's see, it looks like this is more just generic, or not generic, but just stuff about the presentation and getting credit.
There is a few questions in the Q&A. Logos need to be copyrighted, ?
Yes. Okay. So Nicole's question, logos need to be copyrighted. Again, if it's a logo for your business, so there's the trademark on the one side. Do they need to be copyrighted? Well, again, if it's original, the copyright, it magically appears with the creation of the logo. So if my copyright is unique to me, it's a drawing I came up with, then the copyright's created there. Do you have to register that copyright? No, it's I don't want to say it's a force of nature, it's an act of nature, but that's kind of how the law is, that it automatically happens. But there are benefits to registering that copyright, and there are reasons you may need to register it, but you don't have to do it. And again, on the trademark side, you don't have to register that logo to get trademark rights. You create this logo, and once you start using that logo with your goods and services, you'll create the trademark rights. Again, it's a thing that naturally happens with that. So the logo doesn't have to be either copyright or registered for copyright or trademark, but there are reasons you might want to do that. Okay, on to Todd's question. Can you clarify if your company name is trademark or copyrighted, or both? So a name could be trademark, not copyrighted. Copyright, it has to have a little more authorship and originality, and names don't cut it. They're not good enough. So company name is going to be a trademark. Is it a business idea that's trademark? I guess I don't know what you mean by that, but you know, the trademarks apply to goods and services. So if I'm selling something, I put my name on that good. It's not that idea. It's I have protection in this name associated with these goods. And so, you know, that's where the protection is. It's this name with these goods or these services. So there's this playoff. So you assume the company logo is copyrighted to the business, not the graphic designer who made it. Again, this is going to go back to you have the agreement in place that says, hey, graphic designer, I'm hiring you to make a logo for me. I'm going to own the copyrights. So we'll take the assume out of that, get that in writing before you pay money and have that graphic designer do the work. And that's great. Afterwards, same thing. We can kind of clean that up and get a writing that says, hey, I created that for you. I give you the copyrights, but get a writing. We don't want to argue about it, fight about it. Do either of those things, just writing. Okay, does the legal entity of a company need to be set up and registered with the state before you register for trademarks or copyrights? So this is a tricky kind of question, because these are rights. For the most part, they can be, you know, kind of bought and sold and transferred around. The one exception here is you file a trademark for intent to use. So if I come up with a trademark, I'm going to start selling shoes and I'm going to call them Orange, you know, and I file an intent to use trademark application. Then I create a legal entity. We'll call it Orange Smiths. And Orange Smiths is going to be the one selling those shoes. Well, there's problems there, right? So if you're registering an intent to use, you have to make sure it's the company that is gonna use the mark. So if I'm registering it and I the individual say I'm the owner when it's really the company, then that's a huge problem. So it can be a little tricky. But if you're a company and if you start using a mark, and that's fine. And then let's say I started using it individually, and then 2 years from now, I'm like, you know what? This is really taken off. Goodbye law practice, hello shoe practice. Then it's okay. I can give all the goodwill, all my trademarks to my company, even though it didn't exist when it started. That's fine. So the one wrinkle there is if you're going to do this intent to use, that you really want to make sure the company that's going to do it is set while you file that application. There's some ways around it, but that's where things can get a little tricky. So we add the logo, both copyright and trademark. So yeah, a logo, you know, if it's original, it can be both, right? If you don't come up with what the logo you use as your trademark, well, then that's not going to be copyright. So again, copyright has to be original. So it has to be, I came up with something new. And then someone else could come up with it on their own, that's fine. But yeah, I can't take a symbol that's already there and start using it as my trademark and say I have copyrights. But if we hire a graphic designer and they make the logo, then I could have both. I feel like 4 is pretty low for questions, so I'll give people another couple minutes to answer or to ask any other questions they might have. Or
Question just came in. For my magazine, I created a color because the initials are generic. Trademark the color of my logo, right?
okay, so let's see. I created a color. So you have a new color. So you could, you know, if you come up with a new color, you could trademark a stylized word version, right, of the, let's say, initials. So my initials are PJS. I really like green, so I come up with a special green hue for for some sort of goods, then I think you could say you have trademark rights. I could say that because this is somewhat unique to me, and I can kind of I think this would be one where I'd have to show the trademark office a little acquired distinctiveness. And I think saying I created this color and I'm the only one using this color in a stylized version points to enough factors to show that's distinct, and people see that and know that's a specific source. So I think that type of combination would probably give some protection, some level of protection to that logo. Ultimately how much, I don't know, but it may be those initials with that color in that style, but sometimes that's enough. So is a work for hire contract recommended for a graphics designer creating a logo or service mark? So yes, I think most attorneys will tell you anytime you're hiring someone for something, are you giving them money, put it in writing, because it's clear you have something in writing, and it doesn't have to be fancy. It doesn't have to have a bunch of legalese or the party of the first part, the party of the second, none of that stuff. But if you're hiring someone to create a logo for you, you definitely want to have a writing, and you definitely want to put in there that all intellectual property, specifically any copyrights, trademarks, associated with any logos created or anything created, belong to me, the person paying you money to do stuff. That's in a nutshell all the agreement needs to say, to help protect us now, so that later on, if there's a fight, we have some pretty strong evidence, and we could prove that no, in fact, we own this.
Okay, great. I think we have time for one more question. What mark do you use to protect a document that describes your business or key info?
So I guess you wouldn't, I'm thinking perhaps you have Word documents that have your business plan and you put your logo on them. That's fine, but that's not trademark use, right? Because you're not, hopefully, I guess to describe your business, so like an advertisement or like a sell sheet, I'd put as many marks as you have, right? Put all your marks on there. Or if you make a sell sheet that has facts about my company, I've done this for this, almost like a resume. You could have your main logo up top and all other ones around it. That's fine. I mentioned in the US, that's probably not going to be considered trademark use because it's not in association with the goods. If you're offering services, then actually maybe it will. But if you're selling goods, that might not be enough. But it doesn't hurt to use your marks like that. But it won't be use with goods. Again, services, that's pretty good. But I'd say that's, you could use it, but it's not trademark use.
Great, thank you. Well, that is all the time we have for questions today. Patrick, thank you so much, as always, for such a great presentation, such great information. Wishing everyone a safe and fun weekend. Thank you, everyone, for coming.
Thank you all for attending. Thank you for having me, and enjoy your weekend.